The Zoom calendar, Alpha on Thursday. Okay. So welcome everyone to this special water rights in Montana panel presentation hosted by the Missouri Headwaters Partnership. Thank you. I wanted to especially say thank you to our presenters today. So we have with us Maddy Weisz from the Montana Water Court, Andy Brummond from FWP, and Kerri Strasheim from DNRC. And they're going to thank you for taking the time out of your day to come and share your expertise with us. And so for those of you who don't know, MHP includes 9 watershed groups in Southwest Montana. And so those are the Big Hole Watershed Committee, the Beaverhead Watershed Committee, the Madison Conservation District, the Ruby Valley Conservation District and Watershed Council, the Gallatin Watershed Council, the Gallatin River Task Force, the Lower Jefferson River Watershed Council, and the Jefferson River Watershed Council, and the Centennial Valley Association. I think that's how. Okay. And most of them are either in the room here or on Zoom video. So thank you for everyone for joining us. So that I think we're running a little late on time. Sorry about the technical difficulties today, but we'll give each of our presenters a few minutes to just kind of tell us about themselves and who they are and what they do, and then we'll ask some questions that we prepared, and if we have any time at the end, we'll open it up to questions from the audience. So, and on Zoom, you're welcome to type questions in the chat. We'll answer them as we can. Yeah, let's get this thing started, Sarah. Yes, we are recording. Okay, so why don't we start with
All right. Thanks for having me. My name is Maddy Weisz, and I am a water master at the Montana Water Court. I have been with the Water Court for almost 8 years now. And so I focus mostly on, well, exclusively on pre-July 1st, 1973 rights, and we're in the process of adjudicating this. I work in Basin 41G, Jefferson River Basin. So it's nice to be here.
I'm Andy Brummond. I work with Montana Fish, Wildlife, and Parks. I do water resource and water rights work for the agency. We don't really serve a regulatory role. We're more of a water user, just like almost everyone else is. But I focus on a lot of my work focused on in-stream flow, restoring in-stream flow, and protecting in-stream flow. I've been with FWP for almost 18 years now, and before that, I worked for DNRC. Doing water right permitting and water right changes for 5 years. Prior to that, I was actually involved in our family ranch, farming and ranching with irrigated agriculture.
All right, I'm Kerri Strasheim. I'm the Bozeman Regional Manager with DNRC. We cover Gallatin, Madison, and Park counties out of the Bozeman office. And then Helena office covers the rest of the upper Missouri. Jen couldn't make it tonight, but I'm here on DNRC's behalf. I've been in the Bozeman office since 2005, starting in adjudication, 373 step, moving into new approach briefly, and then getting the management position in 08. Like with Andy, I grew up in Terry, Montana on an irrigated farm, so I have that background. Went to MSU in geometeorology and enjoy working and serving the great people of the state of Montana.
just trying to figure out how to move the L camera down, so it's actually looking nice, yeah. Sure. That's not it. And there's some no turns for sound was to. Yeah, some wind. Come on, bro. Okay. Andy, where are you from? Where was your family's? Where was your family's ranch?
Yeah, Arlington.
Welcome. Okay. Oh, where you saying you're based out of Western?
Yes, sir.
This is Okay, this clicker will lower the output. It's not really that. We'll see going. All right, please. All right, so first question, and you know, when you want to take turns with this, so just jump in and it's really feel strongly about it, but first question is, what is the actual law? Can you give us a bit of a water rights primer or refresher?
I will kind of break down the adjudication and what the water court is tasked with. The water court is looking at all rights that existed prior to July 1st, 1973. The reason that's the date is because after that date, the permit system went into place. And so the water rights prior to that date there just wasn't a central place to have them all down on paper. So the idea was that the water court will go through all of the water rights were filed in the early 1980s. And there's two main parts of the adjudication. The first is the water court is going to look at issue remarks that are placed on those claims by the Department of Natural Resources. And then the other part of that is that water users are given an opportunity to object to each other's water rights or their own water right if there's anything that needs to be corrected. So, and then the water court goes basin by basin and puts those claims into cases, usually organized by source and owner. And then we go through the adjudication process, which is basically just a court case. And oftentimes before we get to the formal court proceedings, the water users will reach some sort of settlement agreement and work out the issues between themselves. But that is the basic structure of the water court, not necessarily the law. That's the process. So yeah, the general rule in Montana is first in time is first in right. And that's kind of the touchstone, the beneficial use of the measure right. That's the basics.
All right, and I'll jump in. First, I'll say we have a great, what I call this our water rights, water law primer. We always have these in our offices. You can get it online in PDF form. And this covers a lot of the aspects in Montana put together by Legislative Services at great reference. It's updated whenever significant legislation changes. With that, then you did a great job pre-July 1st, 1973. And yeah, DNRC does do the claims exam or like the technical assistance to the water court and trying to look at some of the technical aspects of claims. So we have adjudication specialists in DNRC that take on that role. And then we also assist the water court in cases when they request our assistance. So we're happy to help. Love working with Maddie here in 41G. And then for new appropriation side or post July 1st, 1973, after the Water Use Act and our Constitution went into effect, that set out the permitting process. So any new use of water needs to be permitted ahead of time through DNRC, unless it meets a permit exception, such as the small use groundwater uses, which are always an issue, also known as exempt wells. And then there's also change requirements. If you're going to change 4 elements of your water right, that needs to be approved ahead of time through DNRC as well. And so if you're going to change a point of diversion, a place of use, a purpose of use, or add or change a place of storage, that also needs to come in. And so that's kind of a permitting basics. We are also the record keeper. That was set up also with the Water Use Act. And so we keep track of the elements of water rights in our database, our centralized database system. So we're always recommending that people make sure their water rights are reflecting accurately, maintained by ownership, address, mailing address, Making sure that use on the ground matches the paper water rate. So that's like the basics of new approach. There's a lot more to water law, but I'll let Andy decide what else we should cover.
One thing that my agency and a lot of the work I do is involved in what we call water reservations. These are water rights that came after 1973, but they're a little bit different than permits. They're where governmental agencies could acquire water either for in-stream flow, which was the focus of my agency, but other agencies such as conservation districts, Bureau of Reclamation, others could acquire water for future use as well. And so that's one kind of unique aspect that's out there. You hear about a water reservation, and it's just a water right, but it's just a little bit different process for getting those water rights, and including particularly for my agency, hundreds and hundreds of in-stream flow water rights within the Missouri River Basin.
Right. What would you most like to see change in the law, if anything?
Well, I'm sure that anybody who has had to deal with the water court or the DNRC or the district court has probably run into frustrations with the fact that it is such a divided jurisdiction. So the water court can only touch water rights that existed prior to July 1st, 1973. The DNRC deals with permits that came after that and the change applications that came after that. And then if there's a dispute over water rights, that goes to the district court. So one of the things that I find frustrating, and I'm sure the water user finds it even more so, is that oftentimes you'll call the DNRC and they say, oh, we can't deal with that, you have to call the water court. And they'll call the water court, say, oh, maybe that's something that you need to talk to the district court. So if I had my way and got to restructure everything, I think it would be really valuable to the people of Montana to have one place where they could go to deal with all their water rights. That's kind of a pipe dream. But I think that's probably one of the most frustrating aspects of Montana water law is just how disjointed it is right now.
I might touch on a couple of things. One's not technically a law, it's a rule that the NRC uses in evaluating irrigation changes. Where if Bob were to take and have 100 acres of irrigation and he decides he wants to put a center pivot over, he wants to move it over here. The way the administrative rules work, you're not going to have 100 acres over there when you move it from over here. Because the DNRC's rightfully recognized that through changes to sprinklers, you can grow more crop, and that overall increases consumption for the basin. And that's not wrong. That's not really the problem with the rule. The problem is if you're making a change and moving yours to this place, but your neighbor is just staying on the same spot, he doesn't get restricted in that same manner. And so I think it's a matter of equity of treating an acre of irrigation like an acre of irrigation in the water right change process. In all honesty, there's negative impacts due to that, but I think it's more an issue of fairness in how people are treated. Just because one person has to go through the change process, the neighbor doesn't, they get different treatment, and that's really a fair situation in my mind. So that's the one maybe rule change out there, and I know there are people that work in the same world I do, picked against stream flow and say, that's really down, there's a big downside to that. And my answer is, I think the horse is well out of the barn and changing the sprinklers already. So I don't know that we're going to be able to undo that, at least in terms of that consumptive use that's increased with when you move to a sprinkler system. And again, you take less water, but a lot of that water when you're flood irrigating was making it back into the system. Someone else is getting that water, able to use that water. Making a turn for the law change is something the legislature has been struggling forever with regard to these small exempt groundwater developments, exempt wells. I'd like to see some progress. I'm not sure what that progress would be. I mean, I know from my agency's perspective where each of those straws in the aquifer starts to affect stream flow. You know, maybe some tightening up of who can use those and for what purposes might be a good thing to do. And but that's been a very politically tough thing to do.
I got a question more.
Yes.
With all these center pivots going in, you see a lot in the valley, I mean, there's all over. And what you're saying is that would reduce the amount of acres you could irrigate. Yet Jefferson County, in the last 10 years, has increased the irrigated cropland by 2,000 acres.
Yeah.
That's like 10% of the whole irrigated valley cropland. How is that possible? Why isn't it going down instead of going up?
I don't have the good answer. I think that's question 10, and we'll probably touch on that more, but you know, I think that comes down to you're looking at Department of Revenue records.
Yes.
Compared to
Yes.
water rights
Yes.
records.
Yes.
And the two don't coincide very well.
But one of them does it for a reason. The revenue people are taxing you on it, okay? So they're watching what's going on. The water people couldn't care less. They didn't get involved in it.
Yeah, you know, I think if, you know, 20 years ago or more, it was difficult just to map that out and get the two connected. I think in today's world, with the mapping technology we have and the database technology we have, it's unfortunate we're not making a move towards connecting those two. If you have a water right on this ground, probably ought to be paying taxes on irrigated ground there. And if you don't, well, you probably shouldn't be irrigating it.
There you go.
You know, and I can understand why the two have been separated for a long time. That we just weren't equipped or never took the time in this state to really zero in on exactly where were people reusing water, really like an engineered survey or something like that. But I think it's unfortunate that we probably now have the ability to make that tighten that up and bring the two together. But I don't see much appetite for doing that at all.
Not involved.
If we're okay jumping to 8, I do have some data that I think you'll find interesting.
Okay.
That's fine.
I can add to that. Okay, before you do that, will you help me understand what you guys are talking about?
Yeah.
No, exactly. That's so the question that has to do with how the Department of Revenue reflects irrigated acres. And so what has been seen in revenue records is in 2009, DOR has 20,910 acres reflected as irrigated ag land.
In Jefferson County.
In Jefferson County, this is just Jefferson County. And then in 2021, they have 22,387 acres reflected as irrigated ag land. So the one thing we looked at was great. Remember when we did field map all irrigated acres in 1950s, early 1950s. And that was 28,383 acres. So if everyone filed the water right on every acre, we're not exceeding water rights acres in Jefferson County. Now, what we did do is we tried to do just a quick map and have some of those acres moved. Yes, they have. And so if I don't think that there's a huge problem, I don't think there's necessarily a 2,000 acre problem. But is there a new pivot where there maybe wasn't irrigation? Maybe it's some irrigation gone away. So
yes.
yeah.
For the record.
So we illegal water in the NRC, which again we're skipping around a little. You can definitely bring the illegal acres to our attention, and we'll take a look at those.
Going to file an affidavit that
Right.
certainly.
Exactly, and so yeah, we'll talk more about that process, but I did want to let you know that from the 28,000 acres plus we mapped in the 50s, the 22,000 is still less, it's not more, so I don't think that there's new. And so we talked, so I can't speak as a DOR expert, but I did get some talking points because they work right across the hall from me. And so agriculture, to be listed as agricultural property, that's automatic if you own 60 acres or more. But if you own less than 160 acres, you have to apply for this. And so that's one thing with rising property taxes, more people may have applied for that ag status to get a tax break. So that's one reason you might see that increase in acres. Also, they started using aerial imagery in 2009 to determine agricultural irrigated acres. And so that might have made the data more accurate based on what was reported and what they visually could see on the ground from when they did their inventories. And then and when they're doing aerial analysis, and I think many of us have just seen this when we're looking at things ourselves, is that changes from flood to sprinkler to a pivot show up better, right? Pivots are easier to recognize as irrigated versus some types of flood and sprinkler. They're less obvious, and it depends on your crop type too. But those are the things that explain that a little bit, so it's maybe not as bad as a bunch of new water use.
Well, when I asked you, they gave me a list of the 5 top people that increased the acres most. And it wasn't the exempt wells, that's what I thought the problem was, Tim. It was 5 ranches, okay, spread out kind of widely in the county, so 4 of them I didn't even know where the hell they were. But it looks like it was done. I don't know if it's illegal, I don't know if they're doing anything wrong, I'm just saying there's been few locations where in fact they increased the water. And stuff that's been irrigated by quite a bit.
And I know what we hear in our office, and Maddie might hear this too, is once the water court has come back to these basins that haven't had water court activity or DNRC activity for a while. So these second decrees have really made people aware of water and the importance of maintaining and using water. So we have had people like with livestock rights. I know for sure that's been a few court cases where they've like, oh, we need to use this right and we could lose it. And so they start maintaining the rights when they haven't maybe been in the past. Just some talking points, but yeah, I'm happy to explore it further on a detail by detail basis.
One thing, Kerri, did you talk with the Department of Revenue? What I see out there is land that's classified as irrigated, and then there's wild hay land. And sometimes it's not really clear to me, at least looking at aerial photographs and looking at water rights, is wild hay land maybe irrigated land or not. That's one thing I haven't really figured out.
But when your tax bill comes and you show that they raise your taxes on irrigated land and you didn't change your irrigated land, okay, you go back to these people and say, wait a minute, what the hell's going on here? At least I didn't, okay? I've been through this with them over and over again. I've got 4 acres up in a corner that I can't get to that they keep wanting to put on my property. And they don't line up their lot lines and their it's kind of a joke.
Yeah, I remember when they came out with that mapping, they got their field boundaries from the NRCS, but they didn't get them geo-referenced right.
Right.
And, you know, they did something like my family's ranch, some of the irrigated lands across the fence on the neighbors.
Yes.
I tried my hardest to get it corrected. They didn't really seem to care.
No. Thank you. I've been there too.
Okay, well, back to question 2. What would you most like to see change in the law, if anything? I just want to offer you all a message of hope. We have a great process going right now, comprehensive water review within DNRC and our state government. And so we have key stakeholder groups meeting on first one is final decree, and what does that look like? And what are the roles after final decree? And so that group has met a few times, and it sounds like they're making great progress. I can't speak directly to that. I'm not involved. I am involved in the other group, which is everything kind of more new appropriations, the later work permits and changes and the challenges in that group. And, you know, we are listening to the public, gathering feedback, working to streamline our process and make the lanes better, a better fit. So maybe the exempt well lane won't look so appealing if we make a few other lanes easier for people to go through, where we want to see the public notice, where we want to do the other reviews. But maybe it won't be as burdensome as it seems to be today. I encourage you all to take a look at our public involvement aspect, our stakeholder part of our website. Listen to any of the meetings, or watch the meetings after the fact, listen to them live, submit comments to us at any time. We are listening. Okay, it's good to hear.
Okay, so who is intended to enforce water law? Would it be neighbors, the NRC, the water court, or some combination of these, or other?
I think the best answer is some combination, but as far as the water court's role in the adjudication, we are not fact finders. We take the facts that are brought to us and make decisions on them. So that really is a water user driven process. So, you know, if your neighbor hasn't used their water for 20 years, and you don't object to it, it might not get in front of us, and that might never be something that's enforced. So it really is a stakeholder driven process, at least on the water court side of things. There is an option, the dissatisfied water user complaint. If, let's say that you do have your water rights, it's been adjudicated, this is the final word, this is what your water right looks like, but your neighbor's not following the rules. Or you know, several neighbors on the stream aren't following the amount of water that they're supposed to have, you can file something with the district court and get a water commissioner appointed. And then the water commissioner kind of be in the enforcement of that stream. So that is an option, but again, it means signing your name to something and going to court, and it requires 15% of the water users on the stream to sign on in order for a water commissioner to be appointed.
And let's just look at the people on the screen. How about the exempted people that keep putting houses in and sucking the water out of the ground? Are they involved at all?
Not as far as the dissatisfied water users, like, no,
They're not.
no, they're not.
So who pays for the water commissioner?
The water users do, and it's billed through the district court generally.
So would it be billed out to anyone who signed on or the person who initiated it?
I believe that it's billed pro rata, basically, if you get this percentage of the water, you pay by how much water you get.
Okay. All right.
Yeah, and then DNRC does have jurisdiction for illegal water use, wasting of water. The same user, so we have the ability to either work with users on voluntary compliance as our first step, and then depending on the egregiousness of the illegal water use, do take some things into the court realm as well.
You know, in my experience with working on illegal water use complaints, both at DNRC and at Fish, Wildlife and Parks, although certainly in different roles, I think one of the struggles for DNRC is they don't really have an administrative ability to do it. They have to go to court to get an enforcement or an injunction against somebody illegally using water. You know, and some people view that as a shortcoming of the law, that your agency that's responsible for taking care of water really doesn't have the authority to do that. You know, and court battles are expensive, you know, and administrative, well, they can be expensive too, but that it would probably give DNRC some more ability to get some compliance if it was not. Everyone knows that it's difficult for them to have to go take to court. And frankly, it's difficult for other water users to expect other water users to take people to court. That, you know, no one really wants to do that. No one wants to spend the money to do it. Yeah, but the expectation is that people would follow the law.
Can you provide a real world story of how water law plays out in the real world? Such as enforcement actions or legal cases, whatever exactly we do.
I'll go first since I haven't had to go first. I'll give an example, and Maddie brought this up that you know, in the water court, compromises usually are what work things out, and that's frankly true in most of the water. As it usually comes down to gathering the facts and people being reasonable with each other and figuring out what makes sense. And I've been recently involved with one. It involves a lake. Where Fish, Wildlife and Parks has water right on the lake. The lake also has a small dam on it. Person downstream has a right to some water out of that dam, at least the upper part of the lake where it was impounded. At least have a water right claim for that. And there's also a ditch from another creek that both supplies this lake and another watering user. And in that case, Fish, Wildlife and Parks in this ditch had the senior water right. But it turns out when we did some work on the lake, we may have put the head gate in a level too high. And so that water user couldn't get all the water. So we could have took the approach, well, we'll have to fix that, and then you'll be second in line on the ditch, and that's just how it'll be. But what we chose to do is when the lake level was at the point where they could have probably got water in the past, well, we shared the ditch water with them instead of, you know, using our senior right there. So that's an example of where you realize that, well, in a lot of this, is so much of this occurred 100 or more years ago. Figuring out exactly what the facts are can be really tough. And that's my compromise really works pretty well. You at least can figure out what the facts are today and what your best estimate of what should happen. And for our agency, I mean, that's 95% or more of the time. That's how we work out water disputes with people, is we figure out something that's fair to everyone.
Yeah, I wanted to share, we have a recent example of an enforcement action through the court system that was a success. But first I'll just say, we have water commissioners, quite a few in Upper Missouri, and I think everyone who works with our water commissioners, I should say the water commissioners are very happy overall. And it seems to be a system that works. We really rely heavily on the water commissioners. We hear things going on, we're like, oh, can you check this out? Can you take a look at this? And so this one that ended up at court was West Gallatin water. It was somebody down ditch using water illegally. They had a water right for their field, but it was out of a different ditch that they couldn't access. So they were just pumping out of the ditch they could access. And the owners of that ditch were like, no, you don't have a right for this ditch, and he ignored them. Water commissioner was called, tagged the pump, you know, took the tag off in the middle of the night. Water commissioner put up a camera, re-tagged the pump. That all got taken down. And so the Gallatin County attorney wanted to take this to court, through the court action that way. There was an interesting piece of the law of which way is best to go in terms of court of someone else, either the water commissioner or going through the Gallatin County attorney through the attorney's action where you can assess fines for statute. And so they went the fine route, and we went into settlement and we settled, and this person paid a fine. And so it was kind of a successful upholding of Montana water. So.
Yeah, just to echo what's already been said, I have worked for the Montana Water Court for 8 years, and I have only had one hearing. All the other cases in front of me have settled one way or another, and I think that it's just important to recognize that I sit in an office in Bozeman, and I don't know how the water works in the land. And as much as you provide, you know, through discovery documents, historical documents, testimony from people who know how the water works, I will never have as good a knowledge as the people who are out there working on it. So oftentimes, really the best solution for everybody is to reach some sort of compromise. At least in that regard, you have control over the outcome. If you come all the way to court and if you're not willing to compromise, the problem is that you might lose. I might get it wrong. I might get it right. But at that point, it's out of your hands. So I always just really encourage people to get familiar with the law, know what the possible outcomes are, and then try to work with each other to reach something that works for everybody. And on that point, I don't think that people may not realize that the water court provides mediation services. So if you are having trouble with your neighbors or can't work through a disagreement, you can ask for a mediator to be appointed, and you don't have to pay mediation fees. it is just done through the water court, and a water master will act as a third party and try to help people kind of see it from both perspectives and reach some sort of agreement. But I'm a big proponent of the best way to work these issues out is through agreement between the water users.
I have a quick question on some of that, just from my own understanding. So there was obviously a bunch of water use in Montana, in the history of Montana. So pre-73, that was the Montana Constitution, basically codified. If you've been using water up to, it's yours. You just have to file a claim. So the DNRC had to examine all those claims, say what they thought was wrong, right with them. Those are in your court.
Right.
But, and then DNRC has basically examined any water right change since then. You have to go apply for water before you can use it. So you go to DNRC for the post 73 water, pre 73, but no matter what, you have to turn in your neighbor. You can't, there is no authority that you call that can come and do something. You basically have to be the instigator of that and get the ball moving.
Yes.
Yeah, if there's a situation where someone really doesn't want their name involved, I mean, we've worked with people. Often with fish, wildlife and parks, actually, because they have water rights all over the place. So someone calls and something they feel really egregious is happening on the ground, but they don't want their name attached to it. I'm like, well, I can see what's going on. And sometimes I'll contact FWP. They're on the ground a lot more than we are and care about the water resources too. And so they will go take a look, and then it can become an FWP complaint task. And then we'll work on it that way. So there are sometimes workarounds to where if someone's afraid to put their name down, that we can try to figure out a way to not need a name. Because we know sometimes it's not fair out there in the waters and water wars. But
Yeah, and a lot of the enforcement comes from state actors like the Fish, Wildlife and Parks. And federal through the Bureau of Land Management, Bureau of Reclamation, and Bureau of Indian Affairs. And that the United States is involved in a lot of water rights cases before the water court, just trying to protect their own rights to water in the state.
All right. This is along those same lines, are there differences in how the law plays out on the ground versus how it's ideally meant to function?
Well, I think that it's just part of the way that the system is set up, that we have to acknowledge that we are not going to know what's going on ground without it being brought to our attention. And one of the ways it's brought to our attention is through the DNRC putting issue remarks on the claims, and then the other ways through the water users. But otherwise, there are plenty of claims that I'm sure that there are plenty of claims that have problems that just don't get caught, because there is just, like I said, that some basins have a lot of water user involvement, and I think that makes it a more robust adjudication, and you are catching rights that may not be used anymore. But if people aren't involved in participating, there's probably a lot of paper rights that are not necessarily actually being used.
And I think looking at it from a little different angle, you know, what that question could mean, because I think if you found you could read these questions a lot of different ways, and that makes, you know, going back to the question we talked about enforcement, it's like, what do you mean by enforced water? You know, in this case, I guess for me, we're a prior appropriation state. The oldest right beneficially using it gets the water first. But as we've seen success here in Southwest Montana, there's other ways to approach that through drought planning, where we don't necessarily follow that strict priority date. And there's nothing in the law that says that's wrong. It's just different than what the law envisions if you look at it purely as a prior appropriation doctrine. And I think that's been pretty successful. Now, sometimes the prior appropriation, that's That's the way to get it done. That's the fallback position. But I think particularly on larger river systems, that's a tough way to go. On a stream of 5 water users, well, we can all figure out who's got the oldest right and how it should work out. On the Jefferson River, where there's a desire just beyond irrigation to protect in-stream flow, there's a commitment in the local community to do that. There's other approaches that have worked well. And again, it's not contrary to the law, it's just different than what the law is.
And I have seen a lot of agreements where people will agree to subordinate their right to their neighbor's right, because that way everybody ends up with more water. So even though I have the oldest right, I'll let it flow down to you, and then everybody ends up getting the water that they need. So there's lots of flexibility that way as far as reaching agreements outside of priority needs.
Yeah, and then back to what Andy said about people voluntarily leaving water in stream because they understand that value. I think that's so key to recognize, because the West Gallatin, where I'm at, I know the best for a good example. You know, that water, any water you see in the West Gallatin in the summer is claimed. It could be used. That river could be sucked dry 3 times over, but they have made an effort to keep that river wet. And so, but there's a fear because they're not using it, well, they lose it, right? So there's some fear based on the law. I just know that fear's out there. What does that look like? I don't know, but there are some other ways too. I know water commissioners have some flexibility to work with users, and maybe the black and white water right isn't being followed exactly, but it's what works on the ground. I think that's what really is hard, is representing fluid water, which is different every year, in a black and white water, right? For example, claims, we told people to claim the maximum. And in our permitting change process, we're looking at averages. And so it's I think something that we just need to recognize, that water can't really be captured in black and white as much as we try.
Right. Can you provide an example of a particularly difficult basin that has found a workable and a reasonable solution? And if so, how was this accomplished?
Well, when I first started at the court, the Teton River Basin was very contentious and in the middle of the adjudication process, and they were a bunch of 41L cases in front of the water court. And that it seems to, and that's the hard part. Once it moves out of the water court, I don't know how it's going on the ground. But I haven't heard a lot about it. So ideally, I'd like to think that once these water rights are settled and everybody has their water right and says what they get, and they don't have to argue anymore over what my flow rate is and what my period of use is and those sorts of things, that at least it provides some like definiteness, so that then you can negotiate with your neighbor, or you can reach agreements with people because you know what your right looks like. So that's the hope of the whole adjudication process, is that it provides just some kind of finality, and then that lets people bargain, sell, and do what they need to do to make sure that they get the water that they need.
Yeah, I think for me, the Teton was one that came to mind. Actually, Fish, Wildlife and Parks, we lease a couple of water rights on the lower Teton to help maintain in-stream flow on the lower part. So we deal with water commissioners there, as well as our in-stream flow rights, which are very junior, 1985 priority, but sometimes they're a priority. And we're billed by the water commissioner for when those are in use. And so we contribute towards the administration of water there. When I was at DNRC, I actually worked with a DNRC staff, Helen, as well as the water corps, on getting the Musselshell River Basin into, basically getting the information together so that could actually be enforced by a water commissioner. We did that pretty quickly, in a matter of probably less than a couple of months. Water users decided they wanted it, they were going to petition it, and so we quickly as we could Because we had to identify, we had to be able to tell the water commissioner, there's where the pump is, or the ditch is, these are the water rights that go with it. They had to have that information, and it's all out there, but it's not in a place that's, at least at that time, was easily put together. And I think the mussel shell and the Teton are two examples of very, very over appropriated or highly appropriated basins. And I think because of that nature of the, at times, the water supply was so short, the water commissioners have worked well there, although those water commissioners, have found areas where they may be not running strictly by the law. And I'll give an example what I mean by that. In the mussel shell, the water commissioner one year made the mistake of letting a piece of the river dry up. And then later having to try to get that senior water down there was virtually impossible. So they quickly learned, we're not going to do that again, because we have to be able to get this water down there. And I think those lessons, people could argue maybe they're technically not following water rights perfectly. Those are practical lessons the water commissioners learn in those basins. Now, other basins where maybe we're not quite critically as short of water, which is many other basins in Montana, drought planning and things like that. Whether it's the Jefferson, the Big Hole, Ruby, and I hate to start throwing names out there because a lot of basins have worked really hard on that, and have had success with that. And again, I think you could say those were not easy things to do, and they're still in process. I mean, they're still not easy things to do. But I think there's never one size fits all. I think it's really unique to each community, each hydrologic system, as to what's going to work there. And really, it's really about the community of water users and what they value and what they're willing to work on.
Yes, I'll second that. I think the ability of that area to work together is really what determines whether we can get to something more comfortable. One of my kind of favorite examples, water correction, is the issue with period of use. When people had to claim that there wasn't any real standards, and we had some examination standards, but people just, at their kitchen table, I think we start April 15th, so it ended up all over the place, right? Everyone has different periods of use, and you don't normally notice it unless it's an exceptionally dry year and you're looking at when you could start, or how late you could go late season before you're turned off. And I know one tributary to a river came in, and I think one person maybe was going to amend their period of use, and other people, well, if they do it, I want to do it. And ended up, they brought everyone in, everyone kind of standardized the period of use, so then that priority system remains intact on that source. A great solution district.
Interesting. That's one of the things we found at MHPs. We're always working on the same issues, but in different ways, in different situations. So it helps us to come together and learn from each other. All right, so where is the DNRC in assessing closed basins, and how can we expedite this process?
Can I ask more information on this question? What is meant by assessing closed?
Yes.
No.
And actually, it was from Kristen. Kristen, if you're on, I can see a couple of gals in task force, but I'm not sure if any of them are you. So if you're on and you'd like to add context to that, feel free. Otherwise, I'll see if I can pull up your email.
Can you hear me?
No, it did have context. So this is the original question. It says, I would like them to address the question. Oh, no, sorry, that's the wrong. Okay. I would like to know where the DNRC is at in assessing closed basins. A recent analysis that we did indicated that we will run out of physical water before legal water. How can we expedite this process? And that's from the Gallatin River Task Force, and there she's talking.
How many basins aren't closed at this point?
The whole upper Missouri is allowed, so Yellowstone is not, and some of the lower. Although there are months where water's not legally available in the Yellowstone, and not the Yellowstone that I work in. So I guess. Hearing that helps, because we get a lot of, we also get. I think there's some beliefs out there that, well, and it is in statute, that at final decree, sometimes the basins, the closure goes away. Right, and so there is some sense that, oh, well, the basin will be open again, there might be more water available, and I guess what we're seeing today is there probably be more water available, because it really, it is over appropriated generally. And so I was a little worried that was the nature of the question, but it sounds like the question is more about the physical availability of water, and is DNRC going to be able to do anything to ensure that the rivers aren't drying up? And that's actually a great question, and I didn't think about it from that perspective. We don't have a lot of resources put that direction right now, but I know working with our partners, FWP wants to see water in the rivers, and we do really keep our ear open for changes. Some of the stuff we hear first comes from, the people telling us a story, and while there isn't the science and the data right there, like how can I say this really quickly? We heard about spring creeks in the Gallatin Valley having poor water quality and what's going on. And then, so that was one of the first triggers of, oh, something's changing. And then MVMG did come in and find out, oh, wow, well, the water is slowing down. We're not seeing a lot of level drop yet in the Gallatin Valley, but due to the changes from flood to sprinkler, land use changes, not as much water getting stored in that aquifer system. Have less flux through the aquifer. We're seeing that as the slowing down of some of the spring creeks. So, we work with local watershed groups, but I guess I'd probably put some of that back on you all as a local watershed group, because we're a state and we can't, do one size fits all the time. And so we like to work with the watershed group. So if you're seeing a specific problem you want us to assist with, reach out, we'll see what we can do. We've got hydrologists, we've got planners. This is more their expertise fits.
State water plan is sort of trying to address that.
Well, yeah, so we have our living state water plan where we went to basin by basin and got public feedback on that, and that is in there as well. Yeah, we want, the data to be more widespread and easily available.
They made a lot of good recommendations for
Yeah.
water use and water conservation that there's no way to enforce, but at least it's recommendations.
Yeah, and it guides, I think, some of the granting for projects.
Yeah.
All right, Kristen, I think I figured out the audio issues. Did you have anything to add to that?
Can you hear me now? Hello? Hello?
Well, she said she couldn't unmute. Now she's unmuted, but. Oh, it's like the gallery. So it's working in Zoom. But we don't know audio more.
We need a speaker.
Can you switch your speaker? Yeah. It says, I got a speaker set to the owl, so. Can you?
Hello?
Work? Oh, yeah. Here? That makes sense. Okay. Can you say something now, Kristen?
Can you hear me now? Hello?
She says she'll connect later, Kerri. Okay, sorry. Okay, everyone. All right. Oh, well, the last question we had was Bob's question that we kind of already touched on. Probably I can ask it again if we had any better. I'm not sure if we fully covered that. The question about the increase in irrigated crop plan, I think we kind of covered that. Yeah. All right. Well, then that is all the questions we had prepared. Does anybody else in the room have a question they want to ask?
I've got a question. I'm looking at a question. We have spent $500,000 in the last 10 years doing a groundwater survey over that. We had Montana Bureau of Mines and Geology come in here. Got spent 3 years drilling wells and taking better and measuring this and measuring that. And I guess the one simple answer out of all that information is that when you suck a gallon of water out of the valley, in a well, it comes out the roof. We don't know where it comes out for sure. We don't know when it comes out for sure, but we do know that it comes out. Every year, well, not every year, but a lot of years the Boulder River goes dry in my place. The more people we put exempt wells in up the valley, we're taking water out of the river up to as much as 3 million gallons per exempt well if they follow the rules. But they seem to be totally exempt from any of this concern about water rights and that kind of stuff. If I have a problem, I don't go call the last house that was put in the well. They can tell them to stop using their damn well. Okay, I'm supposed to go to my neighbor who's also got a surface water right. So these people that put in these exempt wells get totally, they're out of the picture. They just keep sucking up the water. What are you going to do about that? Because we've got so much water out there.
Yeah, I mean, so our stakeholder group is really trying to get at that. I also think there has to be some local solution. We've been exploring in the Gallatin Valley as well. It's probably very similar to the Boulder Valley from being that alluvial aquifer connected. The tools we have in place right now include a control groundwater area where you can restrict or limit concern based on quantity. There was a statute put into place called streamside depletion zones, which was also trying to get at trying to limit the effect of exempt wells on rivers. It's construed pretty narrowly, so it's been a couple times, but I don't know how applicable it is.
But it's all those water, right? That you want those around really close to the river. You've got to be able to show the effect that river within like 3 months or something.
Yeah, something like that.
It takes some of these things years to get down there.
Yeah,
But it's still going down to the river. I mean, there's no
Right.
question that direction it's going.
correct. So the streamside depletion zone maybe could be modified in legislation to be more applicable as well. Maybe some other tools will come out through the stakeholder engagement process. Like I said, we want to try to get people to use lanes that are more best practice, instead of subdivisions on exempt wells. Is a public water supply a best practice according to the public? And if so, how do we make that the appealing so that it goes through the right channels, but isn't seen as a burden to the applicant? That's what we're struggling with. Like Andy mentioned, we've tried to do things with the exempt wells and legislative process, but there's always a lot of different sides that represent their interests, and so it's hard to find a common path forward of agreement. And so these have stayed there, which they're an exception to permitting. If they stay less than that 35 gallons a minute, that 10 acre feet a year, they can just do it and tell us about it, and that's that.
Well, shoot, we're going well out of water. We're going to run on water before it gets it home.
Now, one thing about that specific statute, Kerri mentioned also, is if you look at the end of that statute, it specifically recognized though that these exempt wells do fall within the priorities.
Yes. But they're being no worries.
I mean, they're not exempt from the priority system. They're exempt because they don't have to go through regular permitting. But what you run into is, I'm sure you're well aware, is, well, how do you figure out what impact each well is having and when? because if you're gonna go to court to fight that, you're gonna have those facts. And that's the difficult part is getting the evidence, so to speak. Now, and maybe at some point that probably will happen somewhere in Montana, and then we'll probably see a move towards mitigation through the existing water rights. If you drill an exempt well in this basin, well, you're going to have to go to the water bank, so to speak, and get some mitigation water to offset that impact. I mean, ultimately, that's probably where this is going. And maybe it's not litigation that drives that. It could be legislation that drives that. It could just be watershed groups moving things in that direction as well. I mean, but I think that's where we need to go. And the legislators, at least in some ways, recognize the need for mitigation. Now, they haven't really taken that step to say that should apply to these exempt wells.
I'm going to talk to the interim water policy committee. They don't want any part of that. The truth about it, no, they don't want to even touch the table. They didn't even want to talk about it. As a matter of fact.
Yeah.
Yeah, but I mean, if you feel like it's really dire, I think our controlled groundwater statute could apply. And that could be a path that's pursued more instantly than hoping for some sort of statewide fix.
The county commissioners haven't got no control with it.
Well, actually, the controlled groundwater area is that has to sign off and county health.
But they can't stop a house from being built. They can stop subdivision. But if you want to just put a house in, they got no control.
That's a big responsibility to put on watershed groups are often underfunded, understaffed. I mean, like down to, one person often. And so when you're thinking about such a big responsibility and sort of the capacity within an agency that's so vastly different than one person. That's seems impossible.
I interpreted when you said watershed groups. Well, maybe I didn't, but I was thinking like, oh, what could we do as a watershed group? And was wondering on a local level about somehow coming up with incentives. Okay, so we can't affect legislation, well, directly, but are there incentives that we could somehow help develop for best management practices or getting more centralized systems? Is that the way maybe that watershed groups can work developing drought plans?
Yeah, I think, and no, I guess I'm not trying to pin it on the watershed group, so you have to do this. But why I say that it was you need the local buy to make these things work. And particularly my feeling is once establish that in one location, in other words, get the paradigm set. This is how it can be done. I think it'll be easier to take it to other places, just like drought planning has been. The first time probably was pretty tough, getting some of that. But now people can use that as an example. I mean, I see when DNRC, when their planners are working with watershed groups or conservation districts, they show examples. So this is what's worked here. This is what's worked here. And then people can look at that and say, oh, well, that we could take that or that, and this would work for us. And I think that's the same with mitigation, particularly for exempt wells and water making. Is once you have that established somewhere, and again, that's not easy to do. I understand that fully. I mean, the funding side, the staffing side, how do you do that? But once the path is shown, I think it's easier for other places to do that same thing.
Are there examples in other states? I know in some ways, as far as the Intermountain West, Montana's ahead of the game a little bit with, you got to figure other places, short of pumping the Colorado dry through the giant pipeline over to Montana to solve our issues. Like what have other states, you would think they'd run into the same thing? populated than Montana? Did they just never have exempt wells, or are there examples of people that did better from the start, or had to go back like us and figure out how to fix the problem?
Not super well versed. There are some very successful mitigation programs in other states, but I know that some of it's a little apples to oranges based on. Also, they've been measuring all their water use too, so they've got all the data they need, which has made it easier, I think, for them to do those programs. I feel like Washington, Oregon have some mitigation banking programs that are successful that include instant flow tests.
Testing one.
Idaho has also been doing a good job. I followed some of their work, trying to restore those falling groundwater tables from the artificial mounting, beavers, flood irrigation to nothing, and then changes in groundwater to be able to maintain that. Idaho's been doing a pretty good job at those approaches. There's definitely some things to be learned out there.
So that's sort of like Idaho does a lot of the like aquifer recharge is a beneficial use where it isn't. People do it.
We do have
it turns it in.
beneficial use.
Oh, we do?
It's usually tied to a mitigation project.
Okay. But
Testing 1, 2, 3.
if irrigators want to just run water in their ditch in the spring before their period of use outside their water right, that's one of those things that it's only illegal if somebody complains, basically. Like if everybody's okay with it, we're all okay with it.
Like control.
Yeah, I think Washington's had some pretty good battles over the impact of wells on streams. It essentially got some development shut down because of that. Yeah, they also have more tools in terms of mitigation and what can happen that way. So there are some examples out there. I would say every Western state struggles with the small wells in one way or another. I would say we're fortunate in Montana that we're a conjunctive management state. In other words, we legally believe surface and groundwater are tied together.
Finally, it took a while to get this. Awesome.
At the same time, there's other states where they're completely bifurcated. They don't believe they know physically they are connected, but legally they don't act that way at all. Now, you could argue that in Montana, sometimes we don't. We're getting better at that. I was involved in litigation in the Smith River when we started to get better at that.
I've got this thing that came in River there, something that outside, it's more water rights in there. It's where they finally got to 41E, where I am. And they're going to send this off to the water court and you're going to adjudicate. What the hell does that mean? And when are you going to be done?
So I can't wait. I want to see what you got in the mail, but what it means when we're gonna adjudicate it. That means that we're gonna put the claim in a case and you will get an order from the court telling you what needs to happen next.
Pass that word.
Oh, that can be mercy.
Yeah, it's 41, yeah, it's just not.
But yeah, so what it means is that if your water right has issuer marks, or if it receives an objection, counter objection, or a notice of intent to appear, then we'll bring it into the water court and we'll deal with whatever issues. If there are no issuer marks on the claim and it receives no objections, then you will not come to the water.
I remember for issue remarks, that's the water right claims examiners, they look at the claim, if something looks wrong, they call you. If they can't figure it out with you, they put an issue remark on the claim and then the water has to settle.
Right.
The DNR first term is like warrants.
It depends on, so when you were there, that probably was the case. Now that most water rights have already been through the water court, the DNRC's hands are tied much more than they were. And so most things get issue remarked and will be dealt with after public notice through the publishing of the decree.
I assume all 41 users got that, so they,
So this, there'll be a little spread out mark near water rights.
Hmm?
It's moisture marks.
I think more or less, if you get, tell me if I'm wrong, this is a letter from the NRC saying, check these over and make sure it's right.
Yes, it is.
Yeah, contract. So 41E is gonna go.
Yeah, 41 EU, so that will be decreed soon. If you're getting this letter, that means it will be decreed relatively soon, like the next,
what is soon maybe,
well, yeah.
I go live long.
The hope was that they were gonna be done in 10 years,
That was 50 years ago.
and that was 50 years ago. Now we're saying maybe 10 more years. And we are working with the DNRC, there's, legislative benchmarks that we have to hit. And I think that, we're all working as fast as we can. But yeah, there's a lot more to do still, but we have. The water court has issued 2 final decrees this year, so we're getting closer, hopefully. And then, but the issue is that even when everything's been decreed and everything's final, that's not gonna end waters. So in that sense, I don't think it'll ever be over.
You got the rest of your life.
But yeah, so that letter basically is saying, look at your water rights, make sure that there's nothing that, because if your water right, let's say. You said, I thought I had 5 CFS and it only says 3 CFS on this abstract. Well, if you want to get that fixed, your only opportunity to do that is right now. When you have when the objection period opens, you will want to object to your own right and say, fix this flow rate.
I got through that, okay.
Yeah, and so initially they were planning on doing a temporary preliminary decree and then a preliminary decree. For every basin, and then they realized that's gonna take way too long, and they changed it so that some basins only have 1 decree. But then they had the exempt stop right filing deadline, and so all of those claims need to be noticed and given an opportunity to be part of the adjudication process. So that's, an additional decree for each basin. So it does seem like a never-ending process, and you probably will get lots more mail before it's all over.
You've got 3 water rights that are not covered in this. Those are the ones that they came around about 3 or 4 years ago and asked us to put new ones in, okay, for stock water and that kind of thing. You're not going to adjudicate those, or they're adjudicated by somebody else, or
Those are the exempt rights, is that what you?
they must be exempt.
mean?
I don't know if they're exempt. I want to know how much stock water I used and where I got it from.
Yeah, those should be in there.
Well, did you file? Did you
They
file?
listed all 5 water rights. It's only got paperwork on 2 of the 2 old ones.
That's something good to follow up on, because when we do claimant contact, generally we'll do it on anything that had changes. Or first ground exam, which your newly filed ones should have. But maybe they did those at different times, but you haven't seen paperwork on those yet. Because,
I talked to Lori this morning,
yeah.
and she said they weren't going to be done now, or they were exempt rights, you need to worry about it, or whatever it was, just keep going, just go on with it.
Okay.
That was a while.
I mean, there could be a possibility that for that basin, they decided not, so try to get all the newly filed ones in. I know they are trying, the water court,
Like for 41G, a lot of because it was decreed in 2018. So the exempt rights aren't going to be included until the next round.
Okay.
Yeah, so, the thing with the exempt rights is you didn't have to file a right. So you could have a right to the use of water without having filed the paperwork. I mean, that's right, is still valid. You just don't have a piece of paper documenting it.
I haven't seen a check with these new water rights, these new exempt rights, they cost me several $100 to get the water rights.
Yeah. So you filed,
Yep.
yeah.
Now, some people let herself out of file, so I haven't been my file.
Well,
You
you can look up your water right query system. Have you tried doing that?
I got a copy. I just wonder what the reason,
Just didn't get-
why they weren't all together, I guess is my question.
I'll be honest, I've seen for fish, wildlife, and parks, right, because we have wildlife managed areas and stuff, so we have in-stream stock rights. What I've seen is I get one letter that's got the newly filed exempt rights, and then I'll get another letter that's got the rest. So you might be getting another letter.
Yeah,
I know we wanna get. That next decree goes through if we can, and since they were filed in by 18, we should have been able. But we add that in on our end for the land usually. I'm guessing you might get another letter, but as long as you talk to Laura, as long as you know they're in our system.
All I remember is they were very specific about whether the cows actually drank out of the river. If they drank out of a ditch, they didn't want to know that. You didn't know that they got the river.
Yeah. Issue, but yeah, ditches had to be filed on in 82.
So then is that something legislative that would have to happen if, you know, when it's all not done, but all adjudicated, that it could be one agency or one court of who we want, if the Lord wants it, or a DNRC wants, or you could go for anything. You know, the 1973 mark basically didn't matter anymore when it came to enforcement, trying to make calls on water. Is that legislative? I guess it has to.
I think that's one of the things that they're talking about with the final decree working group, because you're right, the water court is decreeing water rights as they existed in 1973. If things have changed since then, I just put my blinders on and I don't hear anything about it. That goes through the DNRC. So ideally, I think by the end of the process, you will have a piece of paper that actually represents your water right as you use it today. And I think that's the goal, but there's a lot of talking and stuff that has to happen before that can actually be a reality.
And final decrees do wrap in the new appropriation side of things, so that'll show the changes, I think, in the permits. I believe we had there's a little bit of a lift on our end to verify old permits and changes, I think, before final decree has to occur. And that is one thing that we're planning on our end. That's not something that we've been doing on everything. That's it, open that.
And one thing that's happened, there's you into is people have made changes to the water rights and not went through DNRC to do that. You know, and that puts people in a tough spot. They made big investments. And that process isn't necessarily an easy process. Go through the changes, particularly after you've made that investment, because you really want to be able to do what you're doing there.
And the idea is that originally was that once the adjudication is complete and we have the final decrees, that the water court will go away and it will not exist anymore. And then there's a lot of talk about potentially changing that, because the idea that there's a degree of expertise in water law at the water court, and why would we just get rid of that? So that's another one of those things that is just, we'll have to see how it all shakes out.
Yeah, be better to see you all scatter into private water law. Well, that could be a good thing too.
All right, let's open it up to the people on Zoom. I think I fixed the speaker issue so we can hear you now. Does anybody have a question for our presenters? And there are no questions, or am I just not hearing you? Oh, there you go. One is in the chat box. A water user's ditch comes through his neighbor's field. The neighbor builds a feedlot and uses the ditch for stock water. This question there. Is there more to that question?
I can just start talking on that a little bit, because that stock use is somewhat fascinating in Montana. The ditch existed pre-73. Well, a ditch, it should be in a water right. So
that's the issue I alluded to earlier. A lot of people didn't know they had to file both their irrigation and their stock use down ditch, so they just filed irrigation. I know the water court sees that in a variety of different ways. I've seen incidental use remarks added on, implied claims get generated. So one person, so I talked about the period of use issue where, well, if one does it, we all do it. That kind of happened, I think, in the Gallatin, someone, oh, that was a higher flood right there. In the Gallatin, I want to say one source, someone was going to try to amend or imply their stock use, but I know that there's a lot of that out there, and some people think there needs to be some sort of centralized fix for that. I don't know what that looks like, but the stock drinking from ditch was never exempt. So if there's not a called out water rate for that or shares that could be transferred, then that could be an issue if that ditch user complains, right? We talked about the neighbors have to bring it to our attention.
Well, you got introduction, I can keep the cows from
Great question.
putting
So what fencing laws are fascinating to me, right? Who has to fence in, who has to fence out?
You gotta be,
I can't speak to fencing.
you gotta be able to get across the.
Right, you got ditches, fence, yeah, that's not my area of expertise.
Mine is that guy.
I never thought stock on a ditch could be contentious until I did hear complaints about how messy that they can really sediment up water down ditch and affect water quality too. And so, I mean, yeah, that could be a potential fight waiting to happen. In fact, if the feedlot builder did not consult with the ditch owner first.
Well, and there is a lot of questions about that you have to, as a senior water user, you make a call on junior water rights, and those junior water rights are stock rights. How do you make this cow stop drinking the water? Fence them out, but. Yeah.
If they have about a cow, should drink any significant amount of water, usually you're getting out of clumps. A cow will drink 30 gallons a day out of that side.
Yeah.
Where you're taking, you know, wonder such money, I get the rate out of it. You walk out of a cow for a few seconds and your next one.
Right, any other questions from Zoom? From the folks on Zoom? Sorry. You can feel free to type in the chat box too. Not sure if anyone's trying to talk right now.
Maybe while we're waiting.
And I have a question.
Okay, yeah, go ahead.
Yeah, this is Tom Harrington. I just wonder if there's been any discussion about compensating irrigators as they reduce their water usage in these dry years out here to try to keep stream flows going. And we've had discussions with commerce and tourism because of the impact of that. Is there anything that the NRC or anything is doing to take a look at how do we compensate irrigators who voluntarily reduce their water usage to sustain stream flows?
I'm not aware of any DNRC internal discussion on that. I'm trying to think, we've talked about whether there should be ways they can be formalized. We try to do a temporary lease aspect where if an external party wanted to compensate irrigators in that type of situation. I think the temporary lease was every 2 out of 10 years, it could be done. Thinking that maybe an in-stream flow partner might be interested in that, but that statute I don't believe got used maybe once or twice, so we haven't. I'm not aware of anything in the NRC at this time for compensation. Ask Andy.
Well, and I think the statute mentioned there was a pretty limited amount of water that was allowed for that, so it wasn't really practical in a lot of situations. Yeah, well, and I think I guess I stutter here because there's no simple answer to the question on how you can do that. I mean, in some cases, on a voluntary basis, there are what people refer to as water management agreements, where maybe a conservation organization makes a deal with a ditch company or water users to, hey, we'll give you this amount of money if you could leave this amount in the stream. The problem is with that is if it's outside the prior appropriation system. And so it could work in some places, and I know of a few examples that has been done. But those situations are usually somewhat isolated. You have to have the right circumstance where you can make the water stay in the stream and the next head gate just doesn't take it. So there are opportunities to do that, but again, since it's kind of outside the prior appropriation system, you kind of make it difficult to work.
I wonder, could that also lead to a situation where people are holding back water until they get paid? Potentially, hypothetically. I mean, hopefully folks wouldn't do that, but.
Yeah, I know that. The language on these agreements went from, I think, shared sacrifice. Some people had issues with the word sacrifice to shared benefit, because healthier riparian areas have a lot of benefits to, I think, everyone, ag users and environmental advocates, fisheries folks. So I like the, kind of the attitude of it being a shared benefit to keep that river system wet. But there's definitely beyond wet, right? So there are the leasing programs, unlimited and FWP for ag users that want to do a more permanent leasing, and I think there are some compensation for those leases.
And those typically work better on smaller water bodies. Maybe a stream with a handful of water users that if you could reconnect. So a mile of stream is typically going dry in August, you can have quite a bit of benefit there. On a big river system, probably the Teton is the one where we've is probably the biggest river system where we've leased water rights. And really there is not to keep 50 CFS rolling down the Teton, it's to keep the last few miles from going dry. And so water leasing is a good tool in the right circumstance. I mean, when it comes to large river systems, it's really not a tool because frankly, it takes a lot of money to do that. And what, it also, in a circumstance where the water stream is not going dry now. So you put some more water back in, and somebody just puts it down their head, and they say, well, look, the stream's still not dry. So everything's fine. You really haven't accomplished anything there. And so there's some downsides to it, why it doesn't work as well, but you get into the compensation thing on larger systems.
It'd have to be this sort of compromise, like obviously you know a lot more about this than I do. Beaverhead's reservoir controlled, so we don't have yet a lot of these issues. The Big Hole has that real cooperative thing where you can see you can watch the stream gauges and see a month as people turn off their head gates, and they're all most of them are cooperating together to keep water in the river, and then losing huge amounts of money on crops. I don't know if there's crop damage insurance that covers that, or if they really would just have to be compensated for cutting back on water. But you kind of have to start with a system where people are cooperating, like on Big Hole, it seems like.
Yeah, and I can't really speak to the crop insurance, but I know there are water users who are losing, huge sums of money in production by putting the water back, and they don't have to do that. So, that's a good point.
So the language shared benefit comes with a shared sacrifice. But it's not necessarily shared. Maybe the benefit is shared, but the sacrifice shared. Oh, maybe not shared by everyone.
Yeah, the shared sacrifice term is from irrigators sharing water and then the closures to fishing, right? Not so 1,000 people could still fish the river either, knowing that those fish are stressed. So that's where the shared sacrifice, I think, original.
They always say shared sacrifice for shared success.
Yeah.
Both of those.
Good.
I had a question about, like, what's the magic dust that makes certain communities better at working together than others? Is it, like population density? Is it like everybody's going to church together? There's one town bar, like, what is it? That
Well, there's no simple answer, of course. It's relationship building. You know, where I think, where we've had success in, I guess, drought planning has been, there's usually some key people that have been there engaging for quite some time. And it just, they built trust with the community, whether it's a rancher, farmer, fisheries biologist, somebody is, you know, an outfitter, whoever it might be. That's where it really starts. It is that it takes time to build those relationships, and that's where, at least in my mind, the success happens.
If you got any examples where you have someone who has an exempt well, turning back their water use, putting more water in the stream. I'm an irrigator, but don't do an exempt well.
Well, I think, you know, there's an educational side to that too. I don't think that a lot of people really make that connection.
They don't at all.
You know,
You could sell a house in Montana, if people would want that house, do with the water rights.
you know, and for some people, that's not going to matter. For some people, it may, you know, if they start to understand that, you know, what they're doing does have an impact negatively on the river, on the water users. I don't know of a drought plan that's really tried to bring in exempt wells.
My concern is that you always ask the irrigators to do something, but the rest of the population, they just get their free ride. They just, you know, if you want to go fishing and that kind of stuff. You just keep irrigating your 10 acres for your horses.
Well, you know, I can relate to that. I can relate to that in the Bitterroot, where Fish, Wildlife and Parks purchases 15,000 acre feet from Pinion Rocks Reservoir and another several thousand from Macomo to help keep the Bitterroot River flowing and temperatures down and flow up. You know, and I took a little offense when there was a study done on that, and like, well, all these new wells going in there, it really doesn't matter that much. It's, you know, and like, I can tell exactly how much we're paying for every acre foot of water we're putting back in that river. So I understand that side of the frustration, and that's maybe something that as watershed groups or other organizations do drought planning need to broaden the fold a little bit and bring in those people. You know, and some will, some won't, just like everything is. You know, you know, and how they deal with that in the Blackfoot is the some that won't, not on the exempt wells, but on just regular irrigation rights. If they're junior rights, they get called to shut off the ones that, you know, and there's a little bit different water dynamic in terms of water rights over there that causes that to happen. But you know, is that the carrot and the stick approach with exempt wells and the watershed planning effort? is okay, you know. You can come on board or you can get called and someone might push it.
Well, not like anybody, have you ever called the residents, water rates? I can't give an example that ever happened, can you? I don't see it ever happen, okay?
Bozeman's drought plan is the closest you get. It's not exempt. But that a municipality enacted measures restricting residents' use of water.
For the city water.
This is for the city water.
Yeah, for like lawn and garden.
And then they just voted to permanently have those drought measures in place, so conservation, so now moving forward. Odd number houses can only water Monday and Wednesday, and you are not allowed to water after, or between the hours of like 9 AM to whatever, 10 PM. And same thing, you can report your neighbor. And, you know, have the city come out and inspect, so it's, maybe that's an example that we could replicate.
Yeah,
Beyond our facility.
trying to incentivize people to be more thoughtful about lawn and garden watering. We did have that example in Bozeman last year where city put restrictions on, but someone had this lush green lawn and you could tell they were getting grief about it, so they put up a sign, I have an exempt well.
There's bills here.
Yeah, so the drought doesn't have too, I see that's where we definitely, I wanna help education, I know there's a logo word, I think Gallatin, you know, some good letters to the editor, guest letters about. It affects you too, your exempt well is coming right out of the river, that just came out today in the Bozeman paper, right there yesterday. A good letter, trying to at least spread the word, so exempt well owners are more aware that their use does have an impact. I have to share my story really quick. I've embraced brown. I don't like to water grass, and so I go brown every year. But fireworks, since right when the fireworks stand opened last year, someone threw one in the bar, and I'm like, "Ooh, that's a, you know, brown isn't the best either. Like I need to get rid of that altogether." Have a technical zone around my house because grass is being on fire too. Right.
So this is a really interesting conversation, and someone who is on an exempt well. And does water my lawn, you know, not excessively, but enough to keep it from dying. And we had a lot of wildfires in the Big Well last year, so fire was definitely, you know, the consideration. Yeah, I just wonder how much information is out there and how much people know about, you know, how much water they should be using, or even how much water they are using, because if you're not on a meter, you know, you just kind of water and then till you turn it off.
Take it for granted a little bit.
Absolutely, so.
I will say the city of Bozeman has put together some great water conservation informational flyers. I'm sure they wouldn't mind if you took those and shared those with your watershed.
The city of Butte does a really good job too, I think, their water management, but you know, it's the folks that are outside of the city that are not on meters that are just kind of.
Yeah. No, it's, when we do water use estimations, you can go lower, if people aren't metered.
Yeah.
It's just fact, people use less.
Yeah.
They know what they're.
Yeah.
Our bill for it. It's cheaper to go metered and.
Any other questions from folks on Zoom or in the room? Right. Well, if that's it from the folks in the room, then thank you so much. This is really educational and
Good job.
very interesting. We so appreciate your time.
Yeah, thank you for having.
Yeah.
Yeah, anytime. Any issue? You know how many people were on Zoom?
A lot. I don't have to count, but I can do the count. I'm just curious.
Especially after.
Yeah. You'd rather know after than before.
Yeah. Oh, somebody else says there were 23 at the high count. They say it one.
I got multiple emails asking if it would be recorded, just from there's a lot of double booking in Dillon tonight. There's some wild Montana, the Southwest Montana, like public land input. Meeting group and water users meetings, so a few people, water users that would want to. At least attend through Zoom, they're gonna watch the,
Yes,
at
yeah,
least they mean to watch.
yeah. We did record it. That's I know.
I really like the question format.
What's that?
I like the question.
Oh, good. Thank you.
Right, it's always hard to know how to prepare for a presentation and then. Gather those questions ahead of time. Like we got down to the bottom of a couple things.
And thank you to everyone who helped put this on, and thank you to everyone for your patience with the technical issues.
Nice job.
Thank you.
Cool.
Thanks everyone on Zoom.
Well, thank you for your work.